But now that there is many more writ petitions than were there on the date of this order, for them to indicate which are the ones which they are addressing.
Or there might be some additional issues also.
There will definitely, because, my lord, the legislation and the ordinance and the act came subsequently.
They're not under challenge.
Because may I, with your permission, just read through the orders? Let us, if we go through the orders, all of this will become clear.
All right, let us see. Let us make a
Very
beginning.
well.
Yes, let us make a beginning. Because if your lordship is just pleased to
Where is
take
that?
up.
Where is that?
Yes, so I have set them in a compilation. We've requested the court master
Where
to
is
keep them out. Just let us see our orders of our court. It's a compilation of documents in IA 26757 of 2018. Your lordships have that. I'm only focusing on the orders. Let us just see how it develops. Yeah.
But we are sorry, we can't provide chairs to all of you.
No, but we are just now I just want to take your lordships through these orders. So let's see how it develops. To page 1.
Yes.
Correct. Now, this, please note, this is the order which Justice, which Mr. Chidambaram was referring to, 16th December 2016, bench presided over by Chief Justice Thakur, page 1. Your lordships have it?
If my learned friends can give us a copy of the.
Yes, we'll give you a copy now. So give it to you. Yes. So I'll just read it.
Yes.
So, Manoj, writ petitions, your lordships would see that a whole bunch of writ petitions are admitted. Issue notice on the writ petitions, specially petitions and other applications. We have heard the learned counsel for the parties at some length. In our opinion, the following important questions fall for our consideration in this batch of petitions. Now, these are the 9 questions formulated. Please see whether the notification dated 8 November 2016 is ultra vires 26(2). Section 717 so-and-so of the RBI Act. This is what Mr. Chidambaram was projecting a short while ago. Does the notification contravene the provisions of Article 300A? Assuming that the notification has been validly issued under the RBI Act 1934, whether it is ultra vires 14 and 19, whether the limit on withdrawal of cash from funds deposited in banks has no basis in law and violates 14, 19 and 21, whether the implementation of the impugned notification suffers from procedural and or substantive unreasonableness and therefore violates Articles 14 and 19, and if so, to what effect? In the event that Section 26(2) is held to permit demonetization, does it suffer from excessive delegation of legislative power, thereby rendering it ultra vires? What is the scope and effect of matters relating to fiscal and economic policy of the government? This is the issue which was raised by the Attorney General and the Solicitor General. Whether the petition by a political party on the issues raised is maintainable under 32, and whether district and cooperative banks have been discriminated against by excluding them from accepting deposits and exchanging demonetized notes. Keeping in view the general public importance and the far-reaching implications which the answers to the questions may have, we consider it proper to direct the matters to be placed before a larger bench of 5 judges for an authoritative pronouncement. The registry shall accordingly place the papers before the Honorable Chief Justice for constituting an bench. Then, Manoj, there is a further narrative with your permission. I'm just skipping a few pages and going directly to page 6. Please go to page 6. Yes. The other broad point, your lordships have that? The other broad point on page 6. The other broad point was about extending the time limit for exemption for use of demonetized currency notes of rupees 500 and 1,000 at specified counters as per the relevant notifications issued in the behalf of the Reserve Bank of India. It was contended that the exemption period provided in the concerned notification is expiring. Hence, it will not be possible to deposit the demonetized notes at specified counters thereafter, even in case of emergency situations like hospitalization, travel by air, by railway, air, etc. In our opinion, whether the exemption period should be extended or not must be best left to the judgment of the government of the day, with a hope, this is important, that the government will be responsive and sensitive to the problems encountered by the common man. Accordingly, we decline to issue any interim directions to the government in the matter of extending the period of exemption and leave it open to the government to take appropriate action in this behalf as may be advised. Now, please go overleaf to page 9, second last paragraph. We further direct that if any other writ petitions or proceedings are pending in any high court, further hearings of those matters shall also remain stayed in terms of this order. We further direct that no other court shall entertain, hear or decide any writ petition or proceedings on the issue or in relation to or arising from the decision of the Government of India to demonetize the old notes of rupees 500 and 1,000, as the entire issue in relation thereto is pending consideration before this court in the present proceedings. We make it clear that the petitioners before the High Courts or others, etc., in respect already instituted and subject, will be free to intervene in the writ petitions pending consideration before this court on the subject matter of demonetization of old currency notes of rupees 500 and 1,000, registry to place before Chief Justice. And your lordship may just, there is an earlier page, paragraph on transfer petitions, which I should have also read, paragraph on page 9. That takes us to the transfer petitions filed by the Union of India for withdrawing all the writ petitions and proceedings pending in various high courts across the country to hear those cases along with the writ petitions in this court. So at the instance of the Union of India, it was consolidated here. Your lordships have passed these directions requiring all of us to come here before this court. Now, this was the order passed on the 16th December 2016. Now, this evolved. Now, please see page 11, which is the next order dated 6th March 2017. Now, this is a bench presided over by Chief Justice Kehar, and your lordships will see those names on page 14. But I will just mention here now there are several writ petitions over here, which are fresh petitions filed, page 11. Your lordship has that. Now, please see, yes, so these are individual grievances. Please go to paragraph 2 on page 11. Very well, I'll start from the top. Learned Counsel for the petitioners in the first instance invited this court's attention to the speech delivered by the Honorable Prime Minister on 8th of November 2016 with reference to the demonetization scheme. Our pointed attention was invited to paragraphs 9 and 10 thereof, where it was clearly expounded that such of the persons who could not get their old notes of 500 and 1,000 currency notes by 30th December 2016 would be permitted to do so at specified offices of the Reserve Bank of India by 31st March 17. The court's attention is also drawn to the notification by the Finance Ministry on 8th of November, which envisaged that old currency notes held by individuals other than banking companies would be permitted to be deposited subject to specified conditions. Condition 9 in paragraph 2 postulates as under: any person is unable to exchange or deposit the specified notes in their bank accounts on or before 30th December 2016 shall be given an opportunity to do so at the specified offices of Reserve Bank or such other facility until a later date as may be specified by it. Based on the aforesaid condition, it was submitted that the notification dated 8 November 2016 was in consonance with the speech of the Honorable Prime Minister. The predicament faced by the petitioners emerges from an ordinance number 10 of 2016. So now the ordinance has come after those questions have been formulated. Issued on 30th December 2016, an extract of paragraph 4 of the ordinance is set out. Exchange of specified bank notes for one, notwithstanding anything contained in section 3, the following persons holding specified bank notes on or before 8th of November 2016 shall be entitled to tender within the grace period with such declarations or statements at such offices of the Reserve Bank of India or such other manner as may be specified by it, namely, and then it talks about citizens of India who make a declaration, and number 2, such classes of persons and for such reasons as may be specified by the notification. So this will specifically come up in this batch of petitions. I'll indicate how. Please go to paragraph 6. Based on paragraph 5 extracted above, so then there's paragraph 5 of the ordinance, it was submitted that an avenue has been postulated for dealing with deposits even after the expiry of the grace period of 30th January 2017. It was pointed out that despite the aforesaid postulation in paragraph 5, no individual has been permitted to make deposits of old currency notes after 31st December 2016. It was submitted that the petitioners had genuine reasons for not being in a position to deposit the old currency notes by 31st December 2016, and yet no attention was paid to the predicament of the petitioners, even though the petitioners had brought out their grievance to the notice by the competent authority. Issue notice returnable, etc., and therefore the petitions were entertained. Then the next order of importance is at page 17. Please go directly to page 17. This is my petitions, is one of those petitions in the caption petition, page 17. This is an order your lordship will see of 21st of March 2017. Please go directly to page 19. Page 19. Issue notice. On our asking, Sri So-and-so Learned Counsel accepts notice. Having heard submissions which remained inconclusive and before proceeding further with the matter, it was felt that this court should ascertain from the Union of India, A, whether the central government intends to exercise its powers conferred under 412 of Ordinance 10 of 2016, and B, if the answer to A is in the negative, The reason why the central government chose not to exercise its jurisdiction, an affidavit may be accordingly filed by the central government explaining its position. This affidavit is also filed, which we will come to, but I'm just pointing out. So this issue of section 4 or clause 4 of the ordinance is very much an issue, and this court directed at that point of time. Now please see the final, the last of the orders, important, 3rd November 2017. Now this is begins at page 20. This is a bench presided over by Chief Justice Deepak Mishra. And your lordship may go directly to page 22. Now, please see, there is a huge batch of writ petitions in the caption. Your lordship say, because now all petitions are consolidated, all have to be filed before your lordship. This included my petition as well. Having heard learned counsel for the petitioners and Mr. Venugopal, learned Attorney General for the Union of India, we think it appropriate that the petitioners should file applications for intervention or impleadment in Vivek Sharma versus Union of India. It is hereby made clear that they can assist the court when the matter is argued with regard to the constitutional validity of the law. That apart, their individual grievance may be dealt with by the Constitution bench, keeping in view the ultimate decision of the larger bench, or if it is otherwise possible, the instant petitions are accordingly disposed of. All pending interlocutory applications are also disposed of. And then one of the petitions is rendered just the infructuous, the last one. It is submitted by Mr. Puneet Jain, learned counsel for the petitioners, that the writ petition has become infructuous. This is because cooperative banks were extended a facility which they were not given earlier by a notification, etc. They were allowed to make the deposits. So therefore, this petition, which was filed by the Jain Cooperative Bank Limited, etc., had become infructuous. So that was closed. The other petitions, including mine, were referred to the Constitution bench, as you have seen. Interventions were allowed to be filed to assist on the constitutional validity of the law. Now, this is the state, your lordships may just note, as far as the orders of this court are concerned. Now, there are a couple of things which I should just mention to you. The Attorney General made a statement on this day, which is actually reported. It's not recorded in the order, but I'm just for completion indicating on the 3rd of November 2017, where he, and we have at page 84 of the same compilation, there's a news report, but I'll just summarize it for you. The difficulty was that once this new act came, holding these currency notes became a prosecutable offense. So people like me had currency notes in 1,000 and 500. We had come to the court and there was a potential prosecution which was being faced. So the Attorney General very fairly made a statement that as far as these petitioners with regard to the notes which they have disclosed, etc., because we made a disclosure in our petition of exactly how many notes we have, there will be no coercive steps which are taken against them. So this is now the background over here with respect to the orders passed by this court. Now just have a look at page 101. I'm not reading it beyond pointing out as to what. So just go to 100. Now this is your lordship's Constitution bench judgment rendered, as you will find at page 101 of the compilation, on 9th of August 1996 in the context of the Demonetization Act of 1978. Your lordships have that? Now, this is again by a Constitution bench, which your lordships have noticed at page 101. I don't want to take your lordships' time over this, except to say that apart from the issue which Mr. Chidambaram had pointed out with regard to the magnitude and whether this power can be exercised at all, the other element which the Constitution bench did is, after examining whether the act and whether the action was constitutionally infirm or not, went into the individual cases of the writ petitions. I'm just pointing out, it happened before the Constitution bench. Even though this was 18 years down the line, 1978, judgment eventually rendered in 1996, but the guardrails were set by the Constitution bench at that point of time in the context of whatever was done way back in 1978, not dismissed as academic. And then for individual grievances, it was examined by the Constitution bench. And you will find that, for example, at page 109, individual writ petitions by various cooperative banks, etc., and their grievances are examined and then dealt with by the Constitution bench itself. So I would respectfully submit, now that your lordships have a very good idea of how this matter progressed, how we are all before this court. Why? Because this court said, don't go elsewhere and come here. Once this court says come here, once this court says it is to be decided by the Constitution bench, to borrow your lordship's expression, it then becomes the duty of the court to decide. Now, Manoj, we are not insisting on whether it is to be decided today or tomorrow. But to shut us out and say that the issue is academic, as is being suggested by the other side, is, according to us, completely improper. Now, Manoj, to answer that other point, there are, as you have seen from so there are substantial questions which are framed, which are already there. Then you have two statutes. So may I just point those out from the compilation? Page 38, just have a look at 38. I'm not going to read anything. 38 is the ordinance, which is subsequent to the framing of those questions. 38. This has the appointed date, clause 3, clause 4. And it came to be substituted by an act which is at page 53. So it becomes Act 2 of 2017.
Ramdevan,
Yes.
Just on fact.
Yes, yes.
See, the earlier demonetization.
Correct.
You have seen Justice Mukherjee's judgment.
Yes.
Is it similar to the present one or it's different?
The answer is yes and no. The answer is yes, because it was, of course, a demonetization of currencies, etc., and a question of whether there was power under the RBI Act to do so. The answer, so to some extent, yes. So there will be some guidance to be obtained from that. But as Mr. Chidambaram mentioned a short while ago, in terms of texture, this is a very different situation because it's over 86% of the currency notes. So
What was the percentage earlier?
it was a very small 1.8%, very high denomination notes.
10,000 rupee notes and 5,000 rupee notes, which your lordship remembers, 1978. Hardly anybody would have seen a 5,000 or a 10,000 rupee note. Today, you have demonetized 500 and 1,000. Somebody, my lord, Rip Van Winkle, thinks that 500 and 1,000 are scarce notes. They are not scarce notes. They represented 86.6% by value. You have taken away 86.6% of the currency in circulation. Therefore, my lord, they are similar, as Mr. Devan said, similar but dissimilar. Your lordship will get some guidance from Justice Mukherjee's judgment,
Yes.
but your lordship will have to go further and examine the enormity of this demonetization.
So, sorry. So, Manoj, just to
The other thing, perhaps, if I remember, those 10,000 rupee notes were very big, you know.
Hardly anybody, I mean, I have not seen a 10,000 rupee note.
I am assuming in those days.
There were large notes. They stopped issuing those notes long ago. There were some notes which were available. Similarly, the earlier demonetization also was a separate law, but that again was not the Mahatma Gandhi series, but the King George or whatever series. There were very few notes at that time in circulation, and therefore they said demonetizer. But you have taken away the bulk of the currency in circulation. And to say that this cannot be examined, this is economic policy. My Lord Justice Ramasubramanian's judgment is on cryptocurrency, virtual currency, policy of the government. RBI issued a circular. Your lordships have held that the circular is illegal by testing it on the ground of proportionality. What else is cryptocurrency and virtual currency? It's an economic policy of the RBI. RBI said we will not allow virtual currency. That's an economic policy which the RBI is implementing through a circular. Your lordship has struck it down on the ground of proportionality. Therefore, my lord, your lordships would have to hear us for some time even to come to the conclusion whether it's not academic. But we are confident we can satisfy your lordship. The issues are not academic, they are very live issues.
If I may add, Miller, to answer the query raised by Miller, so that the earlier.
No, the act is still in force. The act
Yes,
is
of
still in
course.
force.
Yes, of course. The act is a very
The act is still in force.
yes, yes, and it
Maybe I'm just.
no, it is in force.
If they withdraw the act, then repeal that, then perhaps it may become infructuous. Is it so?
No, Manoj, it still
not
won't
sure.
be so long as they give us value.
The act is now occupying the field.
No. If you repeal the act, probably then.
Then it will be a different, story altogether. Why should any one of us get into those hypothetical questions?
No. Just.
I understand. These questions are bound to come. We're bound to answer them.
Well, one thing is the act, the other is the notification of 8th of November. That notification of 8th of November is the one that is squarely challenged, apart from 24 and 26. The notification of 8th of
Mr.
November,
Chidambaram, notification is issued in exercise of what power?
exercise of powers under section 26.
Of the act.
Yes.
RBI.
RBI. All right.
So, Manoj, just to wind up, I might just indicate, in this compilation, you need not turn to it. We have also set out those impugned notifications. So they begin from page 31 onward, just for convenience. So that the notification, there is the Prime Minister's speech on 8th November 2016. There is the statutory notification at page 31. there is the Reserve Bank of India and the Press Information Bureau press statements which they have issued at pages 35 and 37. These are the subject matter of challenge, or to say that, look, we draw sustenance from these particular provisions. These provisions, speeches, etc., indicated that even after 31st of December, at our Reserve Bank of India branches, etc., there will be some specified branches, there will be facilities which were made which will be available. Then in this compilation, I've just placed it. I'm not going to take you to it. The facts as far as I am concerned. So I placed my writ petition which I had filed before this court. I was told that no, come with an intervention application, which is why I'm here before an intervention. I had left the country in April 2016. I returned in February 2017. When I had withdrawn some money. I'm telling you the real issue. This was hard-earned money which I had kept because I had to undergo a knee surgery or something, so I had kept it. I have all those deposits and those particulars. When I come back to the country in February 2017 and make a request that, look, please exchange these notes, etc., I am told, no, that can't be done. It's 1,62,000 as far as this particular party is concerned. It's very, very important. Hard-earned money, you cannot nullify it. So therefore, the constitutional elements come in. 300A, of course, 19(1)(g), 14, proportionality, and livelihood, which we'll come to on life at any rate. But we'll deal with that at an appropriate stage. And the final thing which I'm just mentioning in this particular compilation, we've actually separately e-filed another compilation, but e-filing, I've also given a physical copy. You needn't turn to this. Here, you needn't turn to it. But I want to just mention one thing, what the Reserve Bank of India said. The Reserve Bank of India said that that 16,000 crores worth of these notes, which are the specified bank notes, the value of which was specified, 16,000 crores worth was left outstanding. That is what their statement said on 30th August 2017.
What do you mean by
Before
that?
your
What do you
All
mean
right.
by that?
So what they said, so your lordship recalls that at the moment demonetization was announced, there was a window given for exchange of those notes,
Yes,
etc.
yes.
So basically it fell under two schemes. The Prime Minister very fairly said that, look, the last date is going to be in December 2016 itself. However, for appropriate cases, there will be some extension which is to be granted. That was obviously consistent with the government thinking and policy at that point of time. Thereafter, on 30th December 2016, they introduced an ordinance which said that, sorry, the last date is not going to be anywhere in 2017. It is going to be 31st December 2016 itself. And we are not going to allow any extension, though the ordinance provided for that provision under Section 4, which this court asked the central government to file a reply that, look, are you planning to exercise this power under Section 4 or not? So that's a separate issue. Now what happened? So to answer the question, what the Reserve Bank of India said is that all the currency notes which were cancelled, I'm just using the expression cancelled, or the specified bank notes of 500 and 1,000, which they have received back, it constitutes 98.96% of the notes which were in circulation. But 16,000 crores worth of notes are still outside. This is Reserve Bank of India's statement. Out of that 16,000 crores worth, there may be some which are, which don't justify any leniency or any extension of benefits by the government because they may be unauthorized. So we are not talking. But in genuine cases like mine, where I was overseas, I came back, I have full disclosures. Even those people, in my case, 1,62,000 are completely shut out. So I'm left with holding these particular notes which are of no value. And thanks to the Attorney General's statement which he made, which I indicated to your lordships, we are not being prosecuted. Our notes are with us. We are before this court on this issue. Very important. It's not just some abstract principle. As far as I'm concerned, it's a question of my hard-earned money which has been rendered naught. So that's the issue. So, Manoj, these dimensions are far from academic. They are very, very much alive. And Manoj, I think Mr. Chidambaram will have on the larger issues a lot further to say.
Your Lordship's last question.
Only,
Yes.
Sham, do you want
Yes,
before
yes.
Siddharam starts? That money is still with you without any value, even.
Yes, exactly. It is still with me. And so the answer is yes. It is still with me. In my application now, I have given the specifics as to how many notes of 500 really requires a full hearing, my lord. I mean, having got us all to come over here and make these submissions, now please don't tell us that it is academic or send us back to some other court. Because your lordship, see, they move transfer petitions from across the country and wherever else, we've all come over here now and we waited. So now that your lordships are sitting on a panel of constitution bench, 5 judges, I would respectfully submit that, I mean, it's not going to take very long. I'm sure even on the merits, we will not be taking all great lengths of time and far from wasting the the time of the court is, I think, going to be very beneficial because the guardrails eventually are set out by this court as to what governments can do, what executives can do, and what they can't do. Grateful.
Only one interjection, my lord. Since, my lord, hard-earned money, this, that, and others, that is also taken care of by the Act Section 4. Possibly, there must have been application made and rejected. Possibly, we'll check up. So it's not that hard-earned money, my lord, is taken away.
Made and rejected, is it? Made and rejected.
Possibly, we will have to check up. So it's not as if hard-earned money of everyone goes. There are statutory protections given that you can convert it.
And to
And
answer,
the government, obviously, my lord, would be fully aware of this situation. I didn't want to interrupt, but he said hard-earned money taken away. That's not good. That's
to answer the submission that the 1978 Act, those writ petitions of individual cases were considered by the Constitution bench for good reasons. Kindly turn to page 109 of the order judgment of the Constitution bench. There was an appellate provision under the Act. Appeals were filed. Appeals were rejected. That after they came to the court. Therefore, they were heard again. So it's in an entirely different context, not because the petitions are being tagged along here, they have a right to be heard. So if the
Petitions have been tagged at your instance.
what I'm trying to point out is, there was a reason why they were heard.
Petitions have been tagged at your instance.
Because you didn't want it to face the music throughout the country, that's all.
There is very important reason, very important reasons.
Lord, I was there, Lord, therefore I can say, not face the music. Lord, the idea was there were conflicting orders being passed, interim orders being passed. Therefore, we say that this is a pan-India issue, let the Supreme Court take it. That was the issue.
A matter of moment at that point of time. Therefore, the orders are being passed. So I come back to those 11 questions, the 9 questions. In my very humble submission, many of them are academic. I repeat that statement. If you look at this question, what's the scope of judicial review in matters relating to fiscal and economic policy? I mean, one more chapter to be added by this court in a matter like this. And then again, the next question, whether a petition filed by a political party and the issue raised is maintained with Article 32, does it have any connection with this issue? Therefore, these issues probably are absolutely irrelevant to this point of time.
Mr.
So maybe
Attorney General, what at least we are thinking is, now the act is in force.
Yes.
The notification is still in force.
Yes.
The notification issued under section 24, right?
The act is taken over.
26 operated already. What is the correct way?
No, operated means it has come to an end, is it? Whether it is time bound, the notification.
Yes, my lord.
No, was it for a specified period?
Because my lord,
Yes.
certain consequence follows on 31st of December. That consequence is already followed.
Therefore, it has worked itself out.
Maybe we
Therefore,
may
the
have to
act,
examine. We may
the
have
act
to
now
examine.
occupies the field.
Maybe we may have to examine, Mr. Attorney General.
But then I would probably advise the court that there was limited threshold examination of what would be, if at all the court may have to go further in this matter. I thought a limited threshold examination.
What is
when
the prayer
essential
sought in the
core-
writ petition?
Your Lordship, please.
What is the prayer sought in, at least in,
To set aside the notification.
exactly?
That's right.
That notification
Therefore,
is still
today,
in force.
even if you set aside the notification, the act is in force. So therefore you can't have that's why it's an academic declaration.
No, in some of the petitions, the act has also been challenged.
Act has been challenged, like 24 and
So it
26.
won't become academic in that sense.
And above all, we can only say academic or infructuous, where both sides agree. But if there is a point and a counterpoint, you want to say whether it is infructuous, whether it is.
I quite see that. I quite
We'll have to hear it.
quite see that. But only the concern is before going into the larger canvas which persuaded the government to enter into this very important exercise. I mean, to lay down before the court all those very important considerations taken by the government. And it certainly
That is why
persuaded the court that
the earlier denotification, though, if I am right, it is 78, is it, or 76?
that was
Not examined in which year? 92, is it?
96.
18 years later.
We are the distinction between the 1978 Act and what's happening today is a very important distinction. A large number of developments in economic policy, banking policy, globalization, and impact of monetary policies across the globe. There is a large number of issues, corruption, black money, whole number of issues being taken into consideration by the government. Therefore, my only concern is to what extent the court will enter into all these
That
connected.
of course, we can decide only after hearing
hearing
both of you. We are not able to make up our mind right now, you know.
I understand. We are only trying
We are
to
not
flag
in
the
a position
concern.
to take
No, that argument is always available to you. What is the scope of our judicial review?
But
What are the limitations? So while examining their submissions, we will always be guided by those principles.
I'm not restricting that at all. I'm not saying that at all. But only saying that my concern is the moment you also get into any one of the issues, then there are further issues which keep cropping up. Therefore, I was trying to look at the issues. How many of them are academic today? Will the court go into all those issues at all? Probably that's why I said let's have some threshold
No, no.
for issues.
How can you say that?
Like to go into.
No, how can you say that issue number 7 is only academic?
No, it's not academic.
What is the scope of judicial review in matters relating to fiscal?
There are any number of your lordship's pronouncements on that. Any number of them.
Therefore,
Going back to your lordship.
therefore, in order to answer that issue, we'll have to hear and give our answer to it and say whether it is academic or whether it is not academic or whether it is beyond the scope of judicial review. See, the
Certainly.
point is, as I already said, the government policy, the wisdom of the government is one aspect of the matter. We all always know where the Lakshman Rekha is. But the manner in which it is done, the procedure is something which can be examined and an answer can be given. But for that, it is necessary to hear the counsel, learned counsel.
Certainly, there is no resistance to that at all. But I'm only repeating my concern that even the manner part of it, the procedural part of it, if the court may have to say, yes, the procedure was absolutely, inappropriate, ill-advised, then the court probably would enter into a domain where the wisdom of the procedure followed would also be a matter for declaration by the court. Therefore, in that context, how far the court would travel?
So any
How far
declaration,
the court would travel?
See,
Yeah, that's why these concerns are being flagged.
any declaration one way or the other, any declaration one way or the other is for posterity. And I feel it is the duty of the Constitution bench to answer it
Without
one way
doubt.
or the other.
Without doubt.
Yes.
But your lordships know that in certain momentous decisions taken by governments at given points of time, there are several considerations which are weighty persuasive.
Correct. While answering it, we would take into consideration those
Right.
considerations.
But by only
We understand your apprehensions.
Lord, today your ladyship or my lords may not conclude anything. Let it be heard on some date
Yes.
without, my lord, any further orders today. Your lordships, my lord, have the conspectus of the matter on both sides. We'll address your lordship.
Know whether there is a point and a counterpoint which requires consideration.
Yes,
So we should be satisfied.
yes, my lord. Taken away suddenly and have no remedy. While taking that decision, even the hardship to be faced by honest people like Mr. Divan's client, they're also taken into consideration and provisions are.
Because my lord, your lordship will recollect that every my lord, exemption which is given under this scheme creates my lord a huge my lord, impact. People try to take advantage of that exemption. So it was important to confine the exemption to very narrow limits. Otherwise, there has to be one cut.
All right, what we suggest is let Chidambaram make his submission and let us see, we will see after some time and we will grant you time, there is no problem. But let him make a beginning, let us see how things take shape, right? Mr. Chidambaram, please start.
But our response, the learned AG and me.
No, we will grant you enough time, nothing.
You know, whatever I was trying to place your lordship, only with a certain amount of concern, you're opening a matter like this of large implication. We're not seen as, not inclined to assist the court. That's not, but there are concerns which unfold over a period of time. It is a point I want to be very careful about it. Of course.
But we have answers, our affidavits are in detail and dealing with every submission, which we believe you will satisfy lordship's conscience.
Yes.
Even they will not conclude today, probably only.
Yes.
The overview of them.
We will grant you enough time, nothing to worry. This can't be rushed through also, we know that
Yes.
also.
Your lordship.
But unless we make a beginning, how will you,
Thank you.
let us start, let us see. Yes, Mr. Chidambaram.
Very well.
Please.
I'm grateful.
Yes.
My Lord, let me indicate the scope of my arguments, a broad overview of my arguments. And whenever your lordship wishes to go into the questions more deeply, I will assist your lordships. So the first question is, does the government have the power under Section 26 of the RBI Act to make the notification, which was eventually made on 8th of November? 8th of November. In my submission, the government does not have the power. This was realized way back in
Mr. Chidambaram, before that,
Yes.
if you can give some sequence of events to understand better.
All right, I'll tell you.
Just the sequence, what happened on what day,
I'll tell
just a few,
Well, there are only 3 events to our knowledge, and none of the documents pertaining to those 3 events have been produced, which is one of my complaints, which I will address. According to the record, according to the counter affidavit, and according to what is available in the public domain,
Yes.
on the 7th of November 2016, government wrote a letter to the Reserve Bank of India asking for its recommendation whether 500 rupee note and 1000 rupee notes may be demonetized. The starting point, according to the record, is the letter from the government to the RBI. The RBI board, my lord, your lordship knows, consists of
What exactly is the query to the RBI? What exactly?
Please make a recommendation
Huh.
whether 500 rupee note and 1000 rupee notes may be declared as no longer legal tender.
That was
There
the
is a
query.
letter from the government to the RBI. Much turns on that. On the 8th of November, the next day, the RBI did not take even 24 hours to consider the letter. The very next day, the RBI board meets in Delhi, not in Bombay. It meets in Delhi. The RBI board.
What is the significance? No, Bombay or Delhi, what is its significance?
Mr. Sharma, please maintain the decorum. Please maintain the decorum. No, please don't interrupt the proceedings like this.
There will be one side only. I'm not saying anything. I'm saying only all the advocates.
You are interfering in the administration of justice.
They are extending just for nothing. And all the advocates, they are not only one advocate, they are all advocates are sitting and trying to see the court proceedings. They are helpless. Somebody should request them be one side, that I am requesting them to be one side. Nothing more than that.
Oh, please, just simply disturbing.
Then I should take the assistance of Mr. Sharma.
See, for your information, we can't see the attorney from here, for your information.
I'll keep standing, Your Lordship.
No.
On the screen we can see.
On the screen. There is no screen on the other side? No.
There is a screen, but I don't know whether.
Oh, that is covered.
No, that side they have a smaller screen.
There is a small screen here. There is a screen here.
Anyway, if they hear it's sufficient, they need not see faces. Okay.
All of you are hearing, no? The discussion, all of you are hearing. What will you do, old people, by seeing us? All 60 plus. No, I don't know. Sorry, it was wrong.
Let the document.
What will you do by seeing us?
Now that
But everybody is
appetite
standing
is
over
whetted
here.
by television.
Everybody is
Everybody
standing over
wants
here.
to see everything.
Okay. All right. Yes, Mr.
I want only the document to be made.
All right. Please take your seat.
Say all the advocate do is telling just for nothing. He should
All
sit in
right.
back.
Now you can hear, see,
The best.
this is,
I will wear a mask and that will be a good decoration.
oh, all of you have VC links also.
Yes.
Of course, televised also.
Yes.
So that
They can.
explains why.
But when there is no.
I didn't want to say
It
anything.
can't be helped. Yes,
No, Mr. Attorney, it means,
And this is not the first time a constitutional bench is heard. This is always like this, in the court,
no, Mr. Attorney, according to you, even if Sharma goes out, he can see the proceedings.
Yes.
Yes.
He can see the proceedings wherever he is.
On the phone.
Otherwise, if he is interested in seeing,
Wanted to get the BC reading, Your Lordship. I declined and court martial they mentioned before the court. I'm not well. I'm not well.
All
I'm
right.
not well.
What you want, VC link, is it? You want right now, we will provide. Please give it.
Yeah. If BC link is there, I have no objection. I will sit in my.
he is not well, he
Please.
is tested.
Court master declined. I give you my, their reply to. I show my reply, Your Lordship, her reply.
Please give him the link, huh? Give him the link. Right now, you give him the link. All right. It will be done right now. All right. Now you take your seat. Right. Yes, Mr. Chitra.
On the 7th of November, the government writes to the RBI seeking its recommendation on whether 500 rupee note and 1000 rupee notes may be demonetized. On the 8th of November, less than 24 hours after the letter came, the RBI, which has its headquarters in Mumbai, its entire research staff, research department staff in Mumbai, does not meet in Mumbai, it meets in Delhi on the evening of 8th of November, according to information in the public domain. The RBI board, my lord, ought to consist of 10 independent directors under section 8(1)(c, but 7 slots were vacant on that day.
Please repeat. Out of
10 independent directors under 8(1)(c of the RBI Act,
Yes.
only 3 were in place, 7 were vacant. They had not filled it.
All right.
They had not appointed independent directors.
All right.
So the RBI board effectively consisted of the governor, the deputy governors, 4 deputy governors, 4 officers of the central government nominated by the central government, and under 8(1)(d), 2 government officials nominated by the central government, are believed to have met in Delhi and passed a resolution recommending 500 rupee and 1000 rupee notes may be demonetized. This was on 8th of November. That resolution or recommendation.
This was the statutory obligation, right?
Well, actually, the statutory obligation is the reverse. On the recommendation of the RBI, the government may demonetize.
Okay.
Here, it started with the government writing a letter to the RBI. RBI recommendation is transmitted to the cabinet. According to the information in the public domain, the cabinet is already meeting and it's waiting in the cabinet room. This recommendation comes to the government and this recommendation is accepted, and within minutes of the recommendation being received by the government makes the notification of 8th of November. And the Prime Minister, Honorable Prime Minister, goes on television at about 8 p.m. to announce demonetization while his cabinet colleagues are waiting in the cabinet room. They were requested to wait in the cabinet room. Question is, my lord, my lady asked me a question. Is this the procedure contemplated in section 26? Assuming you're exercising your power bona fide under section 26, a matter so serious and so important as demonetization, which will effectively take away 86.4% of the currency, can it be decided in a matter of 24 hours? Between 7th November, when the letter is received by the RBI, the board meets in Delhi, it is transmitted to the cabinet, and cabinet instantaneously accepts it. What is the application of mine? Is this the procedure followed under 26? The first submission I'm making is this is a perverse reversal of the procedure. The suggestion should have emanated from the RBI with research, with facts, with figures, and the entire matter should have been placed before the RBI, and RBI board should have deliberated it on and sent a detailed recommendation. Government should reflect on it, maybe a day, maybe two. Government should reflect on it and pass such an order. All this was done in 24 hours. Now, my lord, our allegation is...
Mr. Chidambaram,
yes.
I don't know. But all these things have to be done in a super secretive manner because it should not leak all these.
Of course you can do it. Of course you can do
what
it.
you said, it should be deliberated for long.
The board has to deliberate.
Huh?
Where did the board? Therefore, what we are asking is, the letter of 7th November is not placed on record. The agenda note for the board meeting is not placed on record. The actual resolution of the RBI recommending on 8th of November is not placed on record. We are now witnessing the Hamlet without the Prince of Denmark. Where is the 7th November letter of the government? Where is the agenda note for the board? Let us see what was disclosed in the agenda note. Did they disclose to the board that by demonetizing 500 rupee note and 1000 rupee note, 15,44,000 crore worth of currency will be withdrawn, which represents 86.4% of the total currency in circulation. There was this incorporated in the government, in the RBI recommendation. Did the cabinet know that 86.4% of the currency will be withdrawn? Well, I can't imagine responsible cabinet ministers approving something which withdraws 86.4% of the currency overnight. Therefore, let us have those. We don't have those documents. The counter does not disclose those documents. It's not attached. Therefore, my lord, the first question is this...
Out of that currency, 98 point, I think...
Only, my lord, 15,44,000 crore worth of currency was demonetized. 15 lakh, I'll tell you, give the exact number.
So what is not demonetized is, I think, between
15 lakh,
1 and 2%.
Yeah, about little fraction more than one. Just a moment, please. Please, you want to answer one? Fraction more than 1% did not return. And in court number 1, the then Attorney General told Chief Justice Thakur's bench, we expect that 3 lakh crore will not be returned, and that will be extinguished from the liability side of the RBI's balance sheet. It will be taken as RBI's profit, and government will get a dividend on the profit. In fact, the entire profit will be transferred to the government. 3 lakh crore. Later, in later hearing, the number was increased to 4 lakh crore. Government will get a bonanza of 4 lakh crore. As my friend Sham said, eventually only about 16,000 crore out of 15,44,000 crore was not returned. And that not returned could be the currency note has been destroyed, lost, washed away in flood, spoiled, or like him, he was abroad, he couldn't exchange it. 16,000 crore out of 15,44,000 crore. Effectively, my lord, every note was exchanged. And of the notes exchanged with the RBI, RBI's annual report says that only 0.0027% of individual currency notes were found to be fake notes. 0.0027% was found to be fake. Every note that had been returned had been accounted for by the RBI. The annual report is there. We replace all that. Therefore, Mullah, the first question is this the way a decision can be taken? Is this a reasonable, prudent decision-making process that you withdraw 86.4% of the currency in 24 hours and don't place those documents in the public domain? Mullah, we have asked for these documents. These documents have never been placed in the public domain. 7th November, 8th November agenda note, and 8th November recommendation. That's the first question. The second question is, does Section 26 give you the power to do this kind of demonetization? If Section 26 gave you the power, then why in 1946 and 1978 did you have to pass a separate law?
Mr. Chidambaram, before going into the legalities, as you understand, because you are a man with great experience.
No, I don't make it.
Generally, what are the objects of this type of demonetization?
They have said three things. Well, the objects of demonetization are rather simple. That is 46 and 78. Currency notes not in use should be taken out of the system because it adds to the liability side on the balance sheet. Well, every currency note issued is a liability of the RBI. That's why your Lordship will see that I promise to pay to the bearer of this note 100 rupees, the governor signs it. It's a liability side. If the liabilities keep mounting by unused or unusable or disused currency, the liability side keeps on increasing. So the liability is extinguished by demonetization. That is one object, which is a well-recognized object. The other situation in which demonetization is resorted to is when there is hyperinflation and your currency becomes worthless. For example, in some Latin American countries, they are issuing the currency, Argentina, earlier in Zimbabwe, the currency became worthless. Even a 100,000 rupee currency note could not buy you even a cup of coffee. It's completely worthless currency. You demonetize it. You demonetize it and replace it by new currency. That for every 100 rupee now we will give you a 100 rupee note. That is a legitimate objective because of external factors, domestic factors. Your currency has become practically worthless. You will now completely replenish the currency. That is the second objective. Well, these are the two objectives, as far as I know. Disused, unused, unusable currency to be taken out of the system and the balance sheet to be extinguished of the RBI. Second is worthless currency to be replaced by currency with worth. Well, the Lordship
What
knows.
about black money and terror funding?
That is what they've now we come to that. They are saying fake currency, one, black money, and fake currency used for terror funding. These are the three objectives mentioned in the notification. We'll take your Lordship through that. But the fake currency eventually turned out to be 0.0027.
Negligible.
I mean, infinitesimal, absolutely negligible. The second then what they said is, they added corruption later, but the notification only mentioned black money. Let's assume black money is the... Now, black money, we've got data, we trace that. Within weeks, days and weeks of this demonetization, Income Tax Department, TRI, seized unaccounted money in 2,000 rupee notes, the new 2,000 rupee notes. If I want to hold black money, nothing prevents me from storing it in 2,000 rupee note rather than 500 rupee note. Well, the three purposes of currency are well known, Millard. Many of your lordships may have been economics graduates. Three purposes of currency is, one is store of value. The RBI says this paper has a value of 100 rupees, the store of value. Other is unit of account, because I have to maintain accounts. I need to know what is my income, what's my expenditure. I have to maintain accounts in some way. So I maintain account in currency by saying I have 1,000 rupees in cash, I have 10,000 rupees in a bank. And the third is medium of exchange. Before currency came, it was barter. Instead of bartering A for B, we now put a value, and that is the value, and the currency mediates the transaction between the giver and the taker. These are the three purposes of currency. Now take the first one, store of value. What they say is you are storing value in an unaccounted money in 500 and 1,000 rupee notes. Therefore, we're going to cancel them. If you had eventually achieved your objective of getting that currency cancelled, it is neither returned or if it's in your hand, after 30th of December, you can do nothing about it. It becomes a worthless piece of paper. But if you issue a 2,000 rupee note, in fact, it's easier for me to store value in a 2,000 rupee note than in a 500 and 1,000 rupee note. What I would require 4 500 rupee notes or 2 1,000 rupee notes, I'm storing my value in 2,000 rupee notes. So when the DRI and income tax conducted searches and raids, they found unaccounted money in 2,000 rupee notes. So whether that objective is achieved or not, they may have genuinely believed that the objective will be achieved. Then on fake currency, within weeks, and I'll give you the dates and places, in Bandipur, 2 terrorists were killed. And on them, on the bodies of the terrorists, they found 2,000 rupee notes. They also found fake currency. So fake currency, fake 2,000 rupee notes. And the third one, my lord, the fake 2,000 rupee notes started surfacing within months because technology is neutral, my lord. If the government can get the technology, the counterfeiter can also get the technology. So it is a different matter that according to us, none of the objectives were achieved, but that may be outside the purview of judicial review, whether the objective was achieved. The point I'm making is, in order to achieve these objectives, was this the method? Did you examine alternative methods? And I will cite the judgments of Justice Chandrachud and Justice Ramasubramanian for the benches, that you are obliged to examine alternative methods of dealing with it. And after examining the alternative methods, you can arrive at a method. Here, did the board examine it? Did the government examine it? Did the government spell out the various methods of dealing with this menace? Did the RBI board address it itself? According to us, nothing was played. There was no agenda note. We want to see the agenda note before the board. What was disclosed to the board? Well, according to my information, it was not disclosed to the board that by demonetizing 500 and 1,000 rupee notes, 86.4% of the currency will be withdrawn. Well, no prudent cabinet minister, no prudent board member will ever agree to 86.4% of the currency being withdrawn from circulation. Anyway, so the second question is, first was the procedure. Second is, does the Act give you the power? If this power was there, why do the 1946 Act and the 1978 Act, the second question, start with the word, notwithstanding anything contained in section 26, we are passing this law. Because in 46 and 78 at least, Parliament felt this power was not there in 26. This kind of demonetization, the power was not there in 26. And therefore, kindly see the 78 Act, Mother. Now kindly see the 1978 Act. Kindly see section 3. On the expiry of the 16th day of January, all high denomination banknotes shall, notwithstanding anything contained in section 26, cease to be legal tender. Why did they put the words notwithstanding anything contained in section 26? Similarly, my lord, the 1946 Act, section 3, on the expiry of 12th day of January, notwithstanding anything contained in section 26. Therefore, my lord, these are indications how Parliament viewed its power. Now you exercise the power under 26 without a parliamentary law, without a debate in parliament. If it's earlier, you had to find another legal peg on which to do demonetization, notwithstanding anything in 26. Can you exercise this? Does this power flow under 26? Our submission will be that this power is not available in 26. This power is not available. That is the second submission. The third main submission, the Lord, will be that the objectives that you set up were false objectives. These objectives could never be achieved by this kind of a notification. I agree, my Lord. The scope of judicial review on that ground will be limited, but we still, within the limited scope of judicial review, whether a government can set up false objectives and pass such a law. The fourth ground will be proportionality. ₹15,44,000 crore by value, equal to 86.4% of the currency in circulation, was withdrawn overnight, leading to horrendous consequences. Horrendous consequences.
You said 86.4%.
Yes. In terms of the value, 2,300 crore individual notes, discrete notes, 2,300 crore notes, 500 and 1,000, the 2,300 crore notes. By value, the value was 15,44,000 crore. And as a proportion of the total currency in circulation, it is 86.4%. That was withdrawn overnight. And the horrendous consequences, your lordships may have said, many families were simply without money. 11 crore people stood in a queue every day to change their money. District cooperative banks were not allowed to receive deposits or exchange notes. The entire farming community was completely at a loss. It was a sowing season, November, sowing season. They did not have money to buy fertilizer, seeds, or hire labor. Wholesale markets were shut down. Prices crashed. Now we have the data. Prices crashed. Weekly fairs in villages stopped. Retail outlets reported a calamitous drop in sales. Industrial hubs came to a halt. Wages were not paid. And casual labor, 33% of all employed persons, amounting to 15 crore, are casual labor, daily labor. They were without work or without income. And the promise they made that 24,000 crore will be allowed to be withdrawn was not honored. Was not honored. That's the Chief Justice Thakur's order records that and tells them you do your best. This kind of horrendous consequences, were they envisaged or contemplated by the RBI board or the government or the cabinet? Did they know these consequences will happen if you withdraw such a large amount from currency in circulation? So is it a proportional way? Is it a proportional measure to achieve even the objectives that you set out for yourself? That is the next. The next ground is arising out of 26.
Mr. Chidambaram, one question.
Yes.
Suppose instead of 86.4%, suppose if they have withdrawn 40%, what would have happened? You had this argument, you would have...
No, this argument of proportionality will be a weaker argument. I concede that. It will be a weaker argument. The argument will remain. Depends on what notes they withdraw. Well, my personal view is somebody did not even know what notes are largely in use. Somebody belonging to the ages thought that 5 rupee and 10 rupee and 20 rupee notes are the ones currently in use. That's not so. It changed long ago. The notes in circulation, which people use every day, the bulk, the overwhelming bulk was 500,000. Overwhelming proportion was 86.4 was 500,000. You don't withdraw 500,000. If you had, say, demonetized only the 1,000 rupee note, maybe the impact would have been much less. But if you demonetize 500,000, thinking that these are scarce notes, only very rich people have, it's completely wrong, Miller. Ordinary
2,000 rupee notes have not withdrawn.
2,000 were issued for the first time.
Issued.
Which leads to the next round.
Introduced.
Now, my lord.
See, the proportionality argument will have to be seen in the context of the justification for this policy.
Yes. And if
Every
the
time it cannot.
justification failed.
No, therefore, objectively, it has to be seen in the context of the justification.
Absolutely.
Not solely on its own basis.
Absolutely, my lord. Even if you're placing burden on the people, if by doing this drastic step, if you are achieving your objectives, they may defend it. But the objectives were not achieved. As I am pointing out to your lordship, 0.002% of the notes were found fake, and the black money shifted to 2,000 rupee notes. So the two objectives were not achieved. They added another objective.
They didn't do this when they banned this, only thereafter.
No, according to me, you should think through that is why there's a board. That is why section 26 says the board must recommend, not the government issues a command to the board. Will you recommend? And the board recommends within 24 hours. Well, let us see the agenda.
The experts should deliberate.
There is enormous research on demonetization. There is enormous research on the impact of black money. There is enormous research on faking. The most counterfeited note, I know, most counterfeited note in the world is the US $1. But they don't care. They say, we are the reserve currency. What does it matter whether somebody counterfeits the note or not? Eventually, you will deposit it in our banks. So we don't care. They don't take any action against the $1 note which is being counterfeited. If counterfeiting was such a serious problem, as my lady says, and you want to achieve it by demobilizing or demonetizing 86.4, then show that it has achieved the objective. No, the question really is not for your lordship to ask, if I may say with respect, did they achieve the objective? Did the RBI deliberate on this objective and then make a recommendation? Did the RBI deliberate on this objective and then make the recommendation? If you meet within less than 24 hours without an agenda note, without research papers, what would you have deliberated? And how is I ask myself, this may not be an entirely legal question. How is the cabinet waiting to receive the recommendation, and the recommendation is received and it immediately approves it? Should not the government deliberate? Should there not be a cabinet note based on the recommendation? I want to see the cabinet note. It should be placed before your lordship. Suppose there is a draft cabinet note, but how do you know what the recommendation will be? Suppose the recommendation was negative. Suppose the recommendation said you can only demonetize 1,000 rupee note and not 500 rupee note. You have to amend your cabinet note. Was the cabinet note amended? Well, nothing of that sort happened. So let them place these documents. Well, the other question that arises out of 26 is, if the 26 is conferring the power to demonetize up to 100%. Let's take an extreme case. Then should it not have some guidelines? Does 26 have any guideline? There is no guideline in 26. So you can demonetize 5%, you can demonetize even 99.9%. Where are the guidelines in 26? Therefore, we are challenging. We are saying read down 26. Read down 26 strictly to say only the government.
Let us read 26 first. Let us read 26.
Please read 26.
So can't it be argued that there is an inbuilt safeguard in 26 too? Because the power by the central government can be exercised only on the recommendation of the central government.
Correct. Precisely, that's my argument. The proposal must be initiated by the RBI. Please see 26.
Yes.
Now, what happens to a case with where the RBI does not initiate a proposal, then should the government keep quiet?
No, RBI can initiate, because our government has, kindly see the section, composition of the
On
board.
the
in section eight.
recommendation.
Section 8. Section 8, the government has its directors there. 8.1b and 8.1d are government directors. 8.1b, 4 directors to be nominated by the central government. And then 8.1d, 2 government officials to be nominated by the central government. The Secretary Economic Affairs is nominated under 8.1d on the board.
But no recommendation comes from the RBI, then what happens?
No
The
recommendation.
government
Then they
hold its
should-
hands and keep quiet?
No, it does not have to hold that. It must ask its directors to place it on the RBI board agenda, have a discussion, let the government, the RBI board take a decision. That decision must be transmitted to the government. Then the government at the highest level will call the governor and discuss, listen, this is what we want to do, and this is what your decision of the board is. Please reconsider your decision. See, it's not, government is not helpless, my lord. After all, the governor is not appointed by the RBI. The deputy governors are appointed by the RBI. They are not, my lord, completely alien to the thinking of the government or the needs of the government. But it must be discussed first in the RBI board before a proposal is initiated. Here a command, virtual command comes and you pass a resolution in 24 hours. At some time, some stage, your lordship has to look into these documents. Now look at 26. My lord, Justice Nazir asked, please look at 26.
Yes.
On recommendation of the central board, by notification, declare that with effect from such date as may be specified, any series of bank notes of any denomination shall cease to be legal tender. Now, if you have the power under 26(2) to declare nearly 100% of currency in circulation as illegal tender, no longer legal tender, should not Parliament have built some guidelines and some principles shall have regard to or shall not have regard to? Some guideline should be there. So this section ought to be read down. And I'll tell you, Lordship, why what we will argue should be read down. It should be read down to mean any series of banknotes means, and that's how they understood it in 46 and 78, 1946 and 1978. Any series of banknotes means of any denomination, not all series of the same denomination. Any means any series, not all. Normally, any includes all. But if you read any as all, where we have now the Mahatma Gandhi new series. Earlier, we had the Mahatma Gandhi series. Earlier, we had the King George, whatever series. Any series is read as all series of banknotes of 500 and 1,000 denomination. If you read it that way, then this is an extraordinary power without guidelines. So any series must be read as any particular series of banknotes of that denomination. That's a submission. We will develop it. That is why, since they wanted to demonetize all series whenever issued of 10,000 and 5,000, they had to pass a separate law. So if you wanted to demonetize all series of 500 and 1,000, you should have had a separate law. And Parliament should have debated it. You can't invoke 26(2). With 26(2), if you invoke and that power is there, please don't interpret 26(2) to convey that power. Who knows, Miller? Today the government has done 86. Who knows? Another government.
Chidambaram, are you suggesting there is no law at all for demonetization?
There is
As of now.
there is no 26(2) ought to be read down. 26(2) does not give the power to demonetize all the series of one denomination.
No, there is one problem, Mr. Chairman.
Please.
See, section 26(2).
Yes.
First of all, we have our own doubts whether you can really call it a case of demonetization, because if you carefully read 26(2), it says, on recommendation of the central board, the central government may by notification of the Gazette of India declare that so and so shall cease to be legal tender,
Yes.
not at all places and not at all times, save at such office or agency of the bank, and to such extent as may be specified in the notification. Therefore, this case is not exactly a case of total demonetization as it happened in the case of 1946 and 1978.
No, well, it's exactly the same. They exchange the notes.
Of the notification at page 33 of the compilation given by Mr. Diwan,
Yes,
it says the notes can be exchanged.
yes,
Windows are open
yes.
at such places and to such extent.
But the same thing was done in the 1946 and 78
That was
by the Act itself.
by the Act itself.
Yes.
Therefore, here the power of the RBI is regulated to say that you can declare it as no legal tender,
Except.
save at such office and to some extent.
But the same thing was done in 46 and 78.
That's right.
Section 7.
In fact, they could have done that, and when they are doing it under parliamentary enactment, they could have done it totally.
Yes. No, but they did not.
That's right.
They did the same kind of demonetization. Demonetized the specified notes, but gave a window for exchange. Both in 46 and 7.
That was provided by the Act itself. Here, when you talk of the lack of power of the RBI, on the ground that there are no guidelines, the provision itself says you have a limited power to say that you cease to be a legal tender, save at such office and to such extent. So these are the two guiding factors for us.
That is an absolute discretion of the RBI. Look, there's no guidelines for that. This is our complaint. If you had passed a separate law where you demonetize a particular denomination and provide a window for exchange of notes, and that is debated in Parliament, and Parliament passes the law, there has been an application of mind to what extent you will demonetize and to what extent you will provide for an exchange. So that is why a separate law was felt necessary in 46 and 78. If you can do that on the 26th, why did they have to have a separate law?
At the time of 1946 Act, this amendment save at such office and to such extent was.
No, Malad, that was the same language. Look at the footnote, Malad. It's just slight change in language. Look at 3, save at an office or agency of the bank. So that saving was always there.
To such extent was
Such extent was not there, but the saving provision, they could have done it to a large extent or a small extent.
Not a case of complete lack of power.
Anyway, my lord, in 1978, this amendment had already come, the saved and to the extent it's come. My lord, Parliament thought, and according to me rightly, that 26(2) does not give you this power. This power in 26(2) is to only demonetize a particular series of notes of a denomination, not all series of a denomination.
But it is by a notification in the Gazette of India.
That is the saving part. Notification of the Gazette of India. By notification, you will specify the note.
Yes.
On the recommendation of the RBI. But the power is the power to notify all series of a denomination or any particular series of a denomination. Our submission will be, for your lordship's consideration, it is only a particular series of a denomination, not all series of a denomination.
But it is not necessary that there should be a legislation for it.
Well,
Because here it says by notification in the
if
Gazette.
you want to demonetize all series of a denomination, and if 26(2) does not give you the power, in my way of looking at it.
As may be specified in the notification, any series of banknotes of any denomination. What do you mean by that?
That means, according to me, you must read it to me, any particular series of banknotes of any denomination. Not all series of notes of 500 denominations.
No,
Any particular series, suppose a series was issued in 1950 and you want to demonetize it, you can demonetize. But you can't demonetize notes were issued day before yesterday. They demonetized notes issued even the previous week. You know, the printing presses print 300 crore notes a month, which is roughly about 10 crore notes a day. It works round the clock. So even yesterday notes were issued, that is demonetized. in 500 and 1000. Does that power there, your lordship will have interpreted, if 26(2) gives you that power, according to me, it does not give you the power. If your lordship interprets it to mean or any means all series, then I would argue then there are no guidelines when you can demonetize all series of a denomination. You must have some guidelines for that.
That depends on the economic wisdom, the wisdom of the powers that be,
Oh, my lord.
and the situation as it develops.
Precisely.
There may be a financial emergency. There may be cases
Precisely.
where the government
Precisely,
have to
guidelines,
act.
Parliament then should say, shall have regard to 1, 2, 3, 4. The economic situation of the country, financial emergency declared, the proportion of currency that will be withdrawn. You know, that is the most important part of demonetization. What is the proposal? Suppose the guideline said, however, shall not withdraw more than 50% of the currency in circulation at any given time. That's a guideline. Yeah, you have no guideline, you can withdraw 100% of the currency in circulation, which is why, my lord, they thought in 46 and 78, this does not give me the power to declare all series of 10,000 rupee note as no longer legal tender. I have to pass a separate law. Now, please see the denominations that were demonetized in 46 and 78.
Just 1 second.